In one ferocious stroke, the Supreme Court has shattered the image of a law and order prime minister and forced Keir Starmer from office. The nation's highest judges did not merely criticize, they condemned. The verdict does not whisper scandal. It declares a constitutional reckoning and a political excommunication. The ruling spans more than 100 pages, delivered with absolute certainty by the Supreme Court. It outlines a catalog of misconduct, concealed gifts, luxury overseas trips masked as official duties, offshore connections to undisclosed donors, and a £24,000 property controversy that prosecutors describe as deliberate concealment. Within minutes of the judgment, Westminster convulsed. Emergency meetings erupted. Aides ran papers through corridors. Newsrooms detonated with breaking banners. Radios blazed with analysis. Social platforms surged with Starmer out and constitutional meltdown trending at global scale. Outside Parliament, crowds gathered in a thunder of voices. Resign now! Number 10 remained a vacuum, with no speech, no defense, and no rebuttal.
Jane, the symbolism is brutal. A former prosecutor, elevated by a reputation for rectitude, is now cast down by the very guardians of the Constitution. The court has drawn a line between the noble promise of integrity and the reality of deception, and it has placed the Prime Minister decisively on the wrong side.
The silence from Downing Street is becoming a character in this drama. No address to the country, no explanation to Parliament, and no contrition for the judgment. In political terms, a vacuum invites resistance. In constitutional terms, it invites crisis because authority abhors a silence at the top.
The machinery is grinding. Reports from within the labor benches suggest coordinated resignation letters. Shadow ministers calculating whether to salvage legitimacy by walking, and backbenchers drafting language for no confidence. The fear is not merely electoral cost, it is moral contamination. Remain too long and complicity becomes indelible.
Opponents have scented blood. Senior conservatives, long bruised by their own storms, now frame this episode as the collapse of a government built on claims of virtue that were not matched by conduct. Reform UK adds that the only possible restoration is a cleanse at the ballot box. The chorus is wide, and it is unusually synchronized.
The international dimension matters. Markets react to instability rather than ideology. When investors perceive constitutional uncertainty, confidence contracts. That is why sterling's wobble is not simply a headline. It is a signal about Britain's premium for stability. And it is a premium that must be defended with clarity and order.
The Supreme Court, in recent constitutional flashpoints, has asserted that executive power has limits when it frustrates parliamentary accountability. That principle is not partisan, it is structural. It is the reason the court struck down an unlawful prorogation in 2019 and the same reason it intervenes when constitutional guardrails are at stake.
Crowds on the streets reflect more than a single rage. They are cumulative. Years of fatigue with evasions, slogans, and the corrosion of trust. The chant "Resign" is not just aimed at a leader. It is a command to a system to remember that legitimacy is never owned. It is borrowed and must be renewed.
Inside the party, calculation is giving way to survival. Senior figures know that a slow bleed is worse than a clean break. Each hour of hesitation multiplies the reputational cost, turning a single judgment into a narrative of unfitness to govern. If the court has spoken clearly, a party that waffles speaks against itself.
The constitutional mechanics of removing a prime minister are neither mystical nor judicial in the ordinary course. Parties depose leaders. The House can withdraw confidence, and the monarch appoints the person most able to command a majority.
courts mark the boundaries. Politics does the replacing. That is the British settlement in practice.
So, the decisive questions now are practical. Does Labour move immediately to assert control, accept the judgment, and rebuild trust? Does the opposition force the issue on the floor of the House? And do the public accept any solution that is not put to them in a general election if legitimacy is judged to be spent?
Britain has been here in different forms. When the law defines the limits of the executive, Parliament must reassert scrutiny, and parties must remember that power flows through the Commons, not around it. The way out is public, procedural, and principled, not private, improvised, or partisan.
If this is to be a reckoning rather than a collapse, transparency must be immediate. Publish the full factual annexes, explain the money trails, and set out a timetable for political transition. Democracies do not heal through silence, they heal through sunlight, sequence, and scrutiny.
The public will judge not only the fall, but the manner of the response. A hurried deflection will not satisfy a country that watched its highest court speak with clarity. A measured, lawful, and accountable process can preserve confidence, even as leaders change.
And that is why the next 48 hours matter. If leadership is absent, others will fill the stage. Party committees, parliamentary alliances, and external actors with louder megaphones than mandates. Process is not paperwork. Process is the backbone of a constitutional state.
Is this the end of Sir Keir Starmer's leadership, or the beginning of a darker chapter in which silence tries to smother accountability? Should Labour move immediately to a leadership change, or should the country be taken to a general election to reset legitimacy? Share thoughts in the comments for this national reckoning. For continuing coverage with clear timelines, legal context, and parliamentary updates, subscribe to Alert View and activate the notification bell. This story will move fast. Stay informed as Britain navigates law, legitimacy, and leadership.